Welcome everyone to the ABA Government Affairs Office social media channels. I am Cathie Hawke with the ABA Division for Public Education, and I am thrilled to be joined here with Elizabeth Slattery, Senior Legal Fellow at the Pacific Legal Foundation and co-host of the podcast DIST. Elizabeth, thank you for joining us here.
Thanks for having me.
And I'd be remiss not to mention that you are also now a member of the ABA Standing Committee on Public Education as well. We're thrilled to have you be a part of that.
I am. I wear many hats.
You do indeed. So the October arguments before the Supreme Court just wrapped up, and I thought we could spend a little bit of time talking about the headlines and what your big takeaway from the first 2 weeks of argument this year were.
Sure. So we've heard a lot heading into this term that it's going to be one for the history books. We've got a lot of big hot button issues coming up, but the arguments in October were really not ones to write home about. And I think the most interesting thing, my most interesting takeaway from the 2 weeks of argument was how active Justice Clarence Thomas was in the argument. You know, before the COVID era, he rarely asked questions during oral argument. In fact, he once went for, I think, a 10-year period where he didn't ask a single question during argument. And he said in interviews that, look, he just wanted to hear what the advocates had to say. And he didn't like that his colleagues were constantly interrupting each other and interrupting the advocates. And he just wanted to hear what they had to say. And then, of course, when the court had to pivot to the telephone only arguments during the COVID era, they tried out a new format where the justices would take turns. It was very orderly, and Clarence Thomas would go at the top of the order after the Chief Justice, since he is the most senior of the associate justices. And people heard he has a lot of questions, and I think it's wonderful that he has continued in the new argument term. Even though they're back in person, he's still asking questions, and I think it's great for people to hear him and hear what he has to say. And it's really fitting that this comes, you know, on his 30th anniversary on the court, which is this month in October.
Yeah, I think this new argument session style has been really interesting, and it's really allowed for some great engagement between the justices and the advocates. And I know last term that was something that a lot of court watchers thought was missing, was some of that back and forth between the justices. And this new sort of hybrid model, I think, will be really interesting as the term unfolds.
Yeah, it's been interesting as a longtime court watcher to see how the court has responded to what people who, you know, follow the court, reporters and advocates, what they've had to say, and they've adjusted oral argument over the years. You know, a few years ago, they added the 2-minute rule where the advocates get 2 minutes to sort of frame their argument before any of the justices are supposed to jump in with questions. And now they've sort of implemented the Clarence Thomas rule where they wrap up and will go through the line of justices to see if anyone has any sort of follow-up questions. So I think it's nice that the court is responsive to what they're hearing from people who are appearing before the court, and also from, you know, reporters and others who watch the court.
So talking about what the justices may or may not be hearing from folks who cover the court, I think we'd be remiss if we didn't talk a little bit about some of the big themes coming into this term and some of the headlines before the court got started in October. And the big one, I think, being the quote unquote shadow docket. So can you tell our watchers a little bit about what this means and sort of why we saw it building as a discussion point over the course of the summer?
Yeah, so, you know, a good deal of the court's work is what some people call the sunshine docket. It's cases that, you know, come up to the court in the normal course of litigation. You know, a district court rules, a lower court, an appeals court rules, and then they come up to the Supreme Court, and the court will, you know, grant review, and in some cases, very small percentage of cases compared with how many petitions they receive each term. They'll hear, they'll get briefing from both sides. They'll hear from interested parties who file front of the court briefs, amicus briefs, and then they'll have oral argument, and then they'll go back, discuss it amongst themselves, and, you know, sometimes many, many months later, issue a written opinion in the case. And that is how many of the disputes that come up to the Supreme Court are resolved. But there are sometimes emergency orders that get all the way up to the court, and, you know, sometimes things do need to be resolved not through the normal channels and not through through the sunshine docket. And in recent years, a number of cases, particularly involving death row inmates, and requests, for stays of execution have come up to the court. Oftentimes they are sort of 11th hour last minute requests. And so they do need to be dealt with on an emergency basis because, the states have an interest in the orderly administration of their criminal justice system and their executions. And at the same time, as they've recognized, death is different and a person's life is on the line. And so sometimes those cases do need to be dealt with on an emergency basis. And in fact, there is a case that the court's going to hear in November that started on the so-called shadow docket, and the court decided that it was important enough. They moved it to the sunshine docket, and they heard they're going to be hearing argument coming up, but we'll talk about that another time.
Great. That's a great plug for our future conversations. Elizabeth, as we wrap up this one, this is the first full term we're seeing with three President Trump's appointees to the court. It's been a big shift in the membership of the justices in the last 5 to 6 years. Can you talk a little bit about what you see the influences of the three newest justices and maybe what we can expect to see over the course of this term?
Sure. So, the saying goes that every time there's a new justice on the court, it's a whole new court. Mm-hmm. And we've had a rapid succession of new courts in recent years, with Justices Gorsuch, Kavanaugh, and Barrett replacing justices who had been there for 30 years in some cases. So it certainly is a different court. We hear a lot in the media about how it's the 6-3 conservative court. But what we learned at the end of last term, and I suspect what we'll continue to see in the future, is that the justices are not cookie cutter individuals. They're not JV politicians. They're not there to rule for one political party or one side, conservative or liberal. I think they do their level best to take the cases as they come to them. And sometimes that means you end up with cases where you have, Justice Clarence Thomas and Justice Sonia Sotomayor agreeing on an issue, but other times you will see the sort of classic breakdown of the justices who are Republican appointees and the justices who are Democratic appointees. But last term, we saw a lot of unanimous rulings and some surprising rulings. For example, one that I think surprised many people because we heard throughout Justice Barrett's confirmation hearing that she was basically, a targeted missile being put on the court, rushed onto the court to strike down the Affordable Care Act. And then what happened? The court heard the Affordable Care Act case. And not only did the court uphold that act, it was 7-2 with only 2 dissenters, and Justice Barrett was in the majority. And so I think that really underscores the fact that the justices are not politicians, and they don't root for, they're not there to root for one side or the other. They take the arguments as they come to them and try to do their level best to dole out neutral and impartial justice.
Elizabeth, thank you for that wonderful analysis and really setting up the field that we may see coming in the next couple of months. And I know the GAO team and our public ed team are thrilled to have you joining us throughout the term. And to our audience today, check back. Elizabeth will be with us throughout the term to provide some expert insight into what we are seeing before the Supreme Court. Thank you so much, Elizabeth.
Thanks.